You are wanted out of the state of Nevada, specifically Clark County, for a robbery. And you are asking me to set you a bond. Is this right? Okay. I don't know anything about you. I'm now getting to know you for the first time. So I don't know. My primary concern is, are you a dangerous person? Because, I have so much drama in my life right now. It's ridiculous. I just don't need any more. And what I don't want to do is release you if you are a danger to my public, because I cherish that, right? I don't need any more. So we're going to find out a little bit about you, and then we'll see where we go from there. Amy, let's get to know Mr. Jefferson.
Yes, so he's wanted in Clark County, Nevada for conspiracy to commit robbery, and theft value over 100,000 or greater. The state's opposed to a bond at this time. He, as the court knows, he's being held. Well, he's not being held. He's made bond also on robbery threats in the 228th and reckless driving.
He has another robbery here?
Yes.
That's local?
Yes, it's a robbery threat in the 228th. It is open. He's made bond on that.
Okay.
So you got a robbery there. You pick up a robbery here too. It's a robbery.
This warrant was also issued December 18th, very recently.
When was bond posted, if you don't mind on that?
Yeah,
He's he's on bond. He's on bond for reckless driving.
Okay.
Picks up a robbery here in September. So I guess he's on bond for a robbery here. And now he's picked up another robbery in Nevada.
Buckle up, guys. Today we're stepping into a courtroom where the tension settles in the air before anyone moves. Judge Fleischer lays out the situation piece by piece. A detainer from Nevada, multiple unresolved cases here, and a history that signals risk. His voice stays calm, but every sentence weighs heavily, as if warning the room to pay attention. The judge isn't just going through procedure. He's framing a reality that could shift his defendant's future entirely. It's the kind of opening that tells you this case is more than paperwork. It's about judgment, trust, and what happens when patterns repeat. Don't forget to like the video and subscribe to the channel. And we'll see you in the next video.
the bond for the robbery threats on September of this year. That case was filed also September of this year. And then this new warrant was issued this December. His reckless driving was.
What court is that out of?
That was the 28th.
No, the reckless driving.
Oh, this one's out of court 10.
What's the court date on that?
That is
January 30th.
on January 30th.
He has a general order bond on that.
Yeah, he's made bond on that one. He also has made bond on the robbery.
And he's made court, has he made, my question is if he's made his court appearances, Your Honor, I mean, I think he's proven that he should go on to court, showing up to court. So if you did consider bonds, he could then, don't worry about the reckless driving.
The state also wanted to add that he was just barely out of parole from earlier this year.
He was what?
Barely out of parole from earlier this year, as they have.
What was he on parole for?
That I don't know exactly.
Mr. Jefferson, I got to be frank. You scare me, man. You know, you continue to pick up cases, and they're serious cases, right? Second-degree felony. I don't know, maybe this is a third degree, but nevertheless, you have a robbery here, you pick up a robbery over there. That scares me. If I let you out, are we going to get a third one? I don't want that to happen. I know you're telling me no, but history tells me otherwise. All the open cases tell me otherwise. Now, I do have some good news for you.
All right, guys. Here's where the tone changes and honesty takes center stage. The judge looks directly at the defendant and says, "You scare me," a line that silences every whisper in the room. It's not anger, but concern grounded in history and behavior. The judge outlines on Nevada now as a countdown. 14 days to pick them up, and if they don't, the defendant could walk free temporarily. But there's a catch. Walking free doesn't erase the warrant. It only delays the consequences waiting just down the road. This moment is less about punishment and more about reality colliding with accountability. The kind that follows you whether you run or stand still. Don't forget to like the video and subscribe to the channel, and we'll see you in the next video.
So there's no holding pattern, meaning that Nevada has 14 days to come get you. And if they don't come get you, then Harris County releases you. So you have that going for you now, but I just don't feel comfortable giving you a bond. You scare me, man. The last thing I want is a third robbery. Do you understand? You gotta understand from my perspective, I don't know you. You're telling me all these gumdrops and rainbows and bunnies jumping in the woods, but you've got all these 3 open cases. They're serious. Sorry, I can't, just.
Okay, he signed on Monday, Judge, so I guess,
So.
can we reset it to, what is that, the 8th?
Case, right, Monday, so 1, 2, 3 days have passed. So you got another, 12 days, give or take.
So can I get a reset for the
2, 3, 4,
8th?
5.
Is that correct? If I'm counting it?
The 7th.
The 7th, even better. Okay.
Yeah, so you said the 23rd?
He signed on Monday, the 23rd is my understanding. So I think the 7th.
Yes, the 7th.
So if they don't come get you on the 7th, you'll be released in Harris County.
So they have until the 6th to come get you, okay? If they don't come get you by the 6th, then on the 7th, you'll be released. But you got to understand, even if we release you, that warrant will eternally remain open. And you could get picked up again the minute you walk out of custody. If you do get out, I would immediately go back to Nevada, take care of that. Otherwise, at some point, you're just going to get picked up again, and it's going to continue to happen.
You can hire an attorney.
And the other thing is that, right, when you do go up there, you got to let your attorney here know what the plans are so that you don't get revoked upstairs here, because then you're going to be in the exact same situation over there like how you are here. You understand? So if you go over there to Nevada and try to handle things and they put you in custody and no one knows about it here in Harris County, you have not advised your lawyer, they may think that you've just jumped ship and they might revoke the bond here, and then they'll place a hold here in Harris County because you're in Nevada. And if nobody knows, you know what I mean? So you got to let your lawyer know here.
You're a misdemeanor lawyer on your record. Do you have a lawyer for both of them, or were you appointed lawyer? Okay, so you need to tell your lawyer that if they don't pick you, you need to contact him, let him know you're in custody. If he doesn't
He
know.
has a lawyer in the felony, so
Yeah.
let your lawyer know in the
You
felony
need to let
case.
him know, and if they don't pick you up, you need to hire someone in Nevada, try to get you bonds on those, or you're gonna have to go out there and address them and turn yourself in and then see if they give you a bond.
All right.
So if they don't revoke your bonds here, you're gonna let your attorney know. You understand all that?
Okay, man. Good luck.
Thank you, Ron.
Thanks, Ray. Thanks, Amy.
I think that's all I have. So see you tomorrow, man.
Yeah,
Hey,
for sure.
Christian.
Dustin,
Come on, Josh.
ready?
Sorry.
All right, who do we have here?
On a Drake Simmons judge. It's
Summons Simmons.
fugitive case.
Good morning, Mr. Simmons.
Yeah, I talked to Day, judge. We have a Greek bond of 5,000.
Okay. So, Mr.
Yeah, he just said that,
You are wanted out of the state of Louisiana for a second-degree battery. Your lawyer has agreed with the state, and you are in agreement, Amy, right?
Yes, Jay is unopposed to a 5K bond.
Okay, I will set your bond at $5,000 today. You have to understand that this is the only time that this is going to happen. We give you 2 weeks from the date of your release to go turn yourself into Louisiana. If you do that, this fugitive case against you gets dismissed. If you fail to do that, I'm going to issue a nationwide warrant for your arrest. I'm going to put your bond at 0, and it's not going to happen again. It doesn't matter what the excuse is. You have to go turn yourself in, and we're giving you enough time to do it. Do you understand? Now, the only other thing I'm going to advise you, don't wait until the last day to go, because as Murphy's Law dictates, what can happen will happen. Something invariably always happens when you go on the last day. Don't do it. As soon as you get out, make the plans to make it up there. Understand? Okay, I got you. We'll set the bond at 5,000.
He needs to have his waiver withdrawn and then also.
Yeah, it appears that he is waived, so he needs to withdraw that waiver.
Okay.
Understand, by withdrawing the waiver, you lose the time that you have by that. But so in the event that he's unable to make bonds, I don't know. That's why.
I'm getting his referral.
Okay,
Okay.
of course.
This is. I'm not waiting for you. Wait for him.
Should I go to court 10?
I should be able to. Thanks. I will talk.
Well, I don't,
I think it goes, just go back to the court.
okay. Good morning, Mr. Rodriguez. Sir, you were charged with assault, bodily injury, and criminal mischief. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You're facing up to a year on both of those cases and or a $4,000 fine.
Judge. On December 24th, 2024, the officer was dispatched to the location and made contact with the complainant. The complainant stated that he followed the sister when she left the house to try to get her to come back. That's when the complainant ran into the defendant, the complainant's sister's ex-boyfriend, and told the defendant he could not be around his sister. The defendant walked up to the complainant really close, and the complainant pushed the defendant to get some space, and the two then began to get into a physical altercation. The complainant stated the defendant bit the complainant's left arm in between the altercation and then ran away. The complainant complained of pain and was advised by EMS to get stitches, and then the defendant was ID'd with mobile APHIS.
You said this was a sister as the complaining witness?
No, Your Honor, the sister was the ex-girlfriend of the defendant. The brother was the complainant.
Got it. Okay. Tell me about the criminal mischief.
On the criminal mischief, on December 18th, 2024, the officer was
So same day.
Same day, Your Honor. No, it was before. The assault was on the 24th, the criminal mischief was on the 18th. So on the criminal mischief on the 18th, the officer was dispatched to a residence in Harris County, Texas in regard to a disturbance. The officer made contact with the complainant who stated that the defendant broke his window with a rock. The officer made contact with a witness who stated that on the 16th, he observed the defendant throwing a rock at the front window, breaking it. The defendant was then observed by the witness leaving the area, returning to the side of the house and throwing a bigger rock at the side window, causing it to shatter while also trying to enter the home through the window. The damage to each window was approximately $1,200.
Both of these happened on the same day, right?
No, Your Honor. The assault was on the 24th, and according to the witness, the criminal mischief was on the 16th of December. So the criminal mischief occurred before the assault.
But I'm looking at the information. The information says December 16th on both.
There is a second assault, Your Honor.
What?
There's one.
On the 31st.
Yes. Oh, okay. My apologies. I was reading because he was just picked up an assault. Let me read the assault that was the same transaction, Your Honor, because he picked up another assault, and that was my apologies. So for the assault on the 16th, the officers were dispatched to a Walmart in regard to service for a disturbance. The officers detained the defendant, and a search of his person revealed 0.68 grams of meth in his right pocket, and the defendant was taken back to the original scene, and the officer spoke to the complainant, who stated that he went looking for the defendant because he was a person of interest in a previous incident. While waiting for police to arrive, the defendant tackled the complainant to the ground and held him in a rear chokehold for approximately 10 seconds, impeding his breath. The complainant stated he felt pain and suffered minor injuries to his person, including a scrape on his left knee.
Now stay with me, because this next case shifts the room into a different energy. The facts laid out describe a confrontation that escalated sharply, leaving property damage and emotions running high. As the details unfold, it becomes clear this isn't just a misunderstanding. There's behavior here that needs immediate correction. Judge Fleischer responds not by waiting, but by ordering an on-the-spot drug test and enforcing strict bond conditions. The tone is controlled, firm, and deliberate. The message is unmistakable. This court steps in before situations spiral beyond repair. And in this moment, accountability becomes more than a word. It becomes action in real time. Don't forget to like the video and subscribe to the channel. And we'll see you in the next video.
The complainant's girlfriend witnessed the incident and saw the defendant choking the complainant. The defendant also admitted to placing the complainant in a chokehold.
All right. Mr. Rodriguez, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If you have a problem with drugs and alcohol, you better address it, because I'm telling you now,
No, it's not a problem, sir.
look at me. If it becomes a problem, I'm going to address it for you. And I promise you're not going to like the way that I do it. Do you understand? I'm going to test you heavily.
That's fine.
What's the name? What is your name, sir?
Mark.
Mark. Hi, Mark. Nice to meet you. I'd like to send Mr. Rodriguez for a drug test right now, please. Stop. Don't say anything.
I consume marijuana.
Stop. I'm sending you for a drug test now. I'm gonna have you come back. I want to see what's going on. That's it.
All right.
But come back. I'll give you a lawyer today. I want to know what's going on with you so that we're both on the same page.
I can tell you.
Don't say anything. Stop. Stop. Go take the test and I want you to come back. I'm going to appoint your lawyer today. As far as your bond conditions are concerned, you're not to have any contact with the complaining witness in this case, not to go where they live, where they work, where they breathe. You're not to be in possession of any weapons. Do you understand? If you violate these conditions, you know what's going to happen. Do you understand? All right, please. So don't worry about conditions because I'm going to have a monitor.
Yes,
Mr.
Judge.
Chong.
Judge.
5,002.
I'm Regina Rodriguez. He's on today's law market.
Okay, great. Come up, sir.
And we have those results.
Great.
Judge, they represent the product for THC, amphetamine, MDMA, cocaine, and everything.
Is there something that's not, I mean, really? Stop. It's a rhetorical question, Mr. Rodriguez, but I'm going to tell you now. It stops today.
Sure.
We're going to do this the easy way, or we're going to do this the hard way. I am giving you the opportunity for you to try to do this on your own. If you are incapable, then you're going to stay with me and we will do it the hard way. Do you understand?
Yes, Your Honor.
You will be required to test bi-weekly here with me so I know that you're not using. And if you show me that you can stay clean, then I will stop. But we will do this in baby steps. But for the time being, you're going to stay here and test a lot with me. Do you understand? I will give you a pass of 45 days on the THC, 45 to 50 days on the THC.
Sure.
But if after that time you continue to test positive for marijuana,
Yes, Your Honor.
I have given you a lawyer. It is your responsibility to stay in touch with Anna. If Anna tells me she can't get a hold of you because you play games, likewise, the bond will go bye-bye.
Yes, Your Honor.
All right? Okay.
Thank you, Judge. We'll see you on
All right,
Monday.
Mr. Rodriguez, see you Monday.
Yes, Your Honor.
Thank you. Can we be excused?
Good morning, ma'am. Ma'am, you were charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On December 16, 2024, officers were dispatched to a Lowe's in Harris County, Texas, in response to a theft in progress. Dispatch stated a male and female suspect had concealed items from the sales floor on the male's person, and a male threatened to hit the loss prevention officer overhead with the hammer while exiting the business. The complainant, the loss prevention officer, let the defendants exit the store and gave a description of the defendant's motor vehicle as it fled the scene. The officers made contact with the complainant, who stated he observed the defendant and the co-defendant, the male, select items off the shelf and conceal them. The defendant was using her purse to cover up items as the co-defendant concealed them on his person. The complainant confronted the defendants as they attempted to exit the business together, and the co-defendant stated he would hit the complainant with a hammer. The defendants were identified by the complainant, and the defendant's motor vehicle was searched incident to arrest, revealing several hand tools. The complainant identified items belonging to Lowe's for a total of $305.35.
All right. And I'm going to find that there's probable cause to go forward with the case. I'm ordering you now not to go to any Lowe's. Do you understand? If you violate these conditions, your bond will be revoked. It will go into custody. No more. Do you understand? Tell me, what do you do for a living? How much money do you make a month, man?
It just depends.
So are you able to hire a lawyer then?
Not at this moment, no.
That's why I'm asking you these questions.
So
Say it again.
Motor on my wheel. So that's the first thing I need to,
How do you support yourself?
self-employed.
I need more than that.
My daughter works as well, so I don't have very many bills.
Okay, so what I'm gonna do is I can give you an application, but if you just put zeros, I'm gonna send it right back to you. I need to know how much money you make, how much money you have in the bank, how many cars you have. If you own a house, I need to know the value of the house. Everything I need to know. Do you understand? Okay. Do not leave until you sign our bond conditions as well, please. Good morning, sir. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 18th, 2024, the officer was dispatched to a disturbance at a residence in Harris County, Texas, and the officer met with the defendant and complainant, who are members of the same household. The officer observed no visible injuries, and the complainant stated she had been living with the defendant for 7 months. So the complainant stated they were arguing in the morning, and the defendant pulled her by her legs off the couch. The complainant stated she hit her head on the coffee table as a result of the defendant pulling her off the couch, causing her to feel pain. The defendant stated the complainant had been evicted and he let her stay with him. And the defendant stated the complainant said something disrespectful, so he pulled her off the couch, but not hard enough to hurt her. The defendant said the complainant then started hitting him and he was blocking hits to defend himself.
Okay. Mr. Whittington, I'm going to find that there's probable cause to go forward with the case. Do we know whether she wants to have contact with him or no?
A rip was attempted, but there is no contact yet with the complainant.
All right. Until I know that she wants to have contact with you, I'm ordering you not to have contact with her. Do you understand?
Yes.
A protective order has been issued in this case. I would get to know it. If you violate this protective order, the state can and probably will file additional cases against you, including a violation of protective order, which is one of the worst cases you can pick up. Just don't have any contact with her and everything will be fine. Do not pick up a new case. Do you understand?
I understand.
We're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Ramona, sign a reset, and then after that, you're on your way. All right? Please, sir. Good morning.
Morning.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On December 18th, officer was dispatched to a driver asleep behind the wheel at 1219 Shepherd Drive. Upon arrival, officer observed a red van with the ignition on and running in a parked position in the middle of the roadway, sitting in front of the railroad tracks. Officer woke up the defendant and observed slurred speech and red glassy eyes.
All right, guys, we close with the DWI case where the numbers speak for themselves. The defendant was found sleeping behind the wheel, and the BAC results come back nearly double the legal limit. The narrative is straightforward, but the consequences are anything but light. Judge Fleischer imposes no alcohol conditions, monitoring requirements, and makes clear that a mistake like this can ripple through every part of a person's life. This isn't just about one night. It's about what happens when responsibility slips and how the law steps in to prevent tragedy before it repeats. The courtroom quiets as the weight of the ruling settles in. Don't forget to like the video and subscribe to the channel, and we'll see you in the next video.
Defendant stated he had left a Christmas party at Club K9 and had consumed multiple Michelob beers. SFSTs were conducted, 6 out of 6 HGN, 5 out of 8 walk and turn, and 2 out of 4 one-leg stand. DIC was read, defendant consented to breath, 0.127 and 0.127, no criminal history.
Got it. Do you see if he has a valid Texas driver license? Do you
I
mind?
can run it now, Judge.
Please. Mr. Miller, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If you test positive for drugs or alcohol, your bond will be revoked. You will go into custody. Do you understand?
Yeah.
You have a lawyer. Because you have one, we will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with counsel. If he comes back and tells me he can't get a hold of you because you're playing games, you're ducking and dodging phone calls, I will issue a warrant for your arrest.
And license is valid, Judge.
As long as you have a valid license and liability insurance in your name, you may continue to drive, but just be careful. If it does get suspended or if you don't have insurance, you're not allowed to drive.
Yes.
We good? Okay. Questions?
No questions, Your
All
Honor.
right. So I'm going to have you guys meet with the coordinator in court 6, and then you guys are good to go.
All right, thank you, Judge.
All right, guys. Happy tidings. Mr. Coleman, how are you, man?
Good.
Looks like you are wanted out of the state of Ohio for robbery in the 2nd degree.
Iowa, Judge.
What did I say?
Ohio.
Oh,
You're close.
sorry, Iowa. Well, not really. Are you waiving formal extradition, sir? All right, sir. We wish you the best of luck. Thanks. Good morning, ma'am. Ma'am, you were charged with 2 counts. You're charged with possession of a controlled substance. You're also charged with theft. Looks like you guys have worked out an agreement where they're going to dismiss the, is this what you want to do, ma'am? You need to understand that this is a very important thing, that you're making a lifetime decision today, that this theft will go on your record. It's going to be there for the rest of your life. You sure you want to do this? You're giving up a lot of rights by entering this agreement. You give up the right to a trial, the right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, there's no turning back. It will stay like this forever. You sure you want to do this? All right. How do you plead to the offense of theft? Guilty or not guilty? I'm going to find you guilty, sentence you to 3 days in jail. I'll give you credit for the 3 days that you've done. I'll roll you a court cost so you won't owe anything. Good luck to you, man. Thanks. Thank you, Aaron. Ma'am, we need you to come back. I do. All right. Good morning, Ms. Franks. Ma'am, you're charged with failure to identify oneself as a fugitive from justice. You're facing up to a year in jail and or a $4,000 fine. Probable cause has already been done on your case. Your case is nearly 300 days old, and it's time to do something with this case. Do you have a lawyer today?
Yes.
Who is it? She has not signed in on this case. Is she going to be here today?
She's supposed to, Your Honor.
Okay, so just go ahead, take a seat for me. We'll wait to see if she says it, ma'am. Okay? All right, do not leave. Good morning, sir. Sir, you're charged with assault of a family member. Your case is 662 days old. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On March 5th, 2023, officer dispatched to a residence in Harris County, Texas, and met with the complainant, who said she had been dating the defendant for 4 years. The complainant stated the defendant had been drinking a lot and noticed his driving was unusual, and told the defendant multiple times to switch so she could drive. The complainant and the defendant switched, and while she was driving, they got into a verbal argument, and the defendant hit the complainant on the right side of her face, causing pain. Once they arrived home, they got into another argument, and the defendant started throwing the complainant's clothing and belongings out of the window of their apartment. The witness was in the car with the complainant and saw the defendant hit the complainant on the back of the head, or on with the back of his left hand on the right side of her face 1 time.
Okay. I'd like to redo the protective order. Listen, one was already entered. Do we need them to do a new one? Mr. Harris, I'm entering in what's called a magistrate's order for emergency protection that identifies the complaining witness in this case. She is now a protected individual. You cannot communicate. You cannot do any family violence, assault, threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon, go within 200 feet of where she lives or where she works. Do you understand? If you violate this protective order, the state can and probably will file a violation of protective order, and it's one of the worst cases you can pick up. Before you leave, you need to get to know this protective order so you don't violate it. I am ordering you not to have any contact with this person and not to be in possession of weapons throughout the remainder of this case. Do you have a lawyer today? We're giving you one today to figure out what's going to happen with this case. Your case is 662 days old, and we set cases for trial at 180. So we're going to figure out what happens with this case. I'm going to have you, well, for now, we'll just have you take a seat in the jury box. If you can reach out to the MAC, please. Good morning, sir. Sir, you were charged with driving while intoxicated, first offense. It's elevated to a Class A misdemeanor because of the high blow. So you were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 18th, 2024, the officer was dispatched to 3000 Southwest Freeway in Harris County, Texas, in regards to the defendant's motor vehicle hitting another motor vehicle and keep going. The caller stated the defendant's motor vehicle's tire fell off and that the motor vehicle was at a strip center parking lot. The officer observed the defendant's motor vehicle facing the Southwest Freeway frontage road and partially on the curb leaned against a hedge. The officer observed the engine running, the defendant's vehicle in drive, and the left front tire shredded. The officer further observed the defendant sleeping, slumped over the steering wheel, and a strong odor of an alcoholic beverage, bloodshot eyes, slurred speech, and the defendant, upon waking, had poor balance requiring the officer's assistance. The defendant stated he consumed 2 mimosa beverages and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 4 out of 4. The defendant was read the DIC and consented to breath. The results were 0.169 and 0.162.
Got it. Any prior DWIs and
No, Your Honor.
license?
Eligible.
Okay. I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're using, I'll put you in jail and I'm going to revoke your bond. Do you understand? What do you do for a living, sir?
I currently don't work. I got assaulted recently. I lost my job.
Where were you working? What were you doing?
I was a Uber and I worked.
Why stop? You still need money. How are you getting money?
I had to do light recovery.
Okay. Did you want to apply for an appointed lawyer, sir? You're going to go hire a lawyer.
I can't afford one. I need a.
That's what I'm asking you. Did you want to apply for an appointed lawyer?
But I will. No, I'm not.
Do you want to?
Yeah.
Okay. If you mind, I'm going to give you an application. I need you to fill it out. I need you to fill it out in its entirety. I need everything. I need to know everything about you. I'll take a look. If you qualify, I'll provide you with a lawyer today. Does he have you said he has a Texas driver license,
I
right?
see an eligible license, Your Honor.
You don't have liability insurance, then you're not allowed to drive. That's car insurance. If you don't have it, don't drive. I'm making that a condition of your bond. You must have a valid Texas driver license and liability insurance in your name. Do you understand? Okay, I'll have you fill out the application, Steve, and I'll have you sign a reset, and then we'll have you take a seat in the jury box. No alcohol, no dope. After you're done with that, you'll meet with pretrial services, so they'll go over your bond conditions.